All rise. The Court of Appeals, Division 1 is now in session.
Thank you. Good morning. Please be seated. This is the time set for oral argument in KOSTADINOVA versus Stevens, our civil number 17-0099. Each side will have 20 minutes within which to make their arguments here this morning. Appellant may reserve some portion of that for rebuttal, but it's up to you to keep track of your time in that regard. We've read the briefs, we've been through the record, we've conferenced the case, so we're familiar with the underlying facts and the issues that you've raised. So please keep that in mind as you make your arguments here this morning. We're recording the proceedings both by audio and video. The video will be available in a matter of days on YouTube. But because we are recording this, I'd ask that as you approach the podium and start your argument that you identify yourself and your client for us. With that, appellant may proceed.
Good morning, Your Honors. I'm Sandra Slayton, and I'm here representing Kristen Roebuck Bethel, the attorney, the real party in interest, if you will, the appellant. Also, Slava KOSTADINOVA, the appellant, is the party is here as well. And Ms. Roebuck will also be assisting me at the table. There are three issues in this appeal. And also I would like to mention that I'd like to try to reserve about 7 minutes for reply. So there are three issues in this appeal. The trial court failed to make the required findings when assessing the sanctions against Ms. Roebuck. This is contrary to this court's decision in Wells Fargo Credit Corporation. And these elements were listed and set forth as well in Wolfinger v. Cheche as well, which we have cited in our brief. So under Rule 11, an attorney violates the objective standard when there was no reasonable inquiry into the basis for a pleading or a motion. There was no chance of success under the existing precedent, and not or, but and, there was no reasonable argument to either extend, modify, or reverse the controlling law. And those findings were not made. The court stated that it was just doing sanctions under Rule 11. It was clear that the court understood the law, but I don't think he applied the law in the end. He rested on the entire history of the case, and in so doing, he violated the mandate and the holding of the Boone case, in which this court confirmed and reaffirmed really the nationwide holding up to the United States Supreme Court and all the out-of-court cases that we cited as well, that the conduct which has to be dealt with in a Rule 11 is like a snapshot. It's like a snapshot in a camera. And that conduct is...
You're saying that history has no bearing whatsoever on the filing of a pleading.
I don't believe so, Your Honor. Not the way I read the very strict elements of Rule 11.
Your client says in her pleading that mother has done nothing vindictive in this case. That has no bearing on to look at what has gone on in the case. Is that your position, Ms. Slayton?
Well, you can look at the background of the case. However, Your Honor, it's my position that in choosing to assess the sanction, the court has to rely on what she's done. In this case, it was filing the response. So the court didn't say, oh, because let's just take your statement, Your Honor. The
It wasn't
court,
it was the judge's statement.
okay,
Your client's statement.
the court did not say, I am sanctioning Ms. Roebuck because I'm making the specific finding under Rule 11, or in this case, Rule 31, that Ms. Roebuck shouldn't have said, Ms. KOSTADINOVA has done nothing vindictive in the case. Because that statement was not true, I'm going to sanction her. That's not what the court said. Instead, the court made broad, sweeping findings that somehow Ms. Roebuck should have known that the court was going to find that she was unreasonable and give her attorney's fees, and because of that, she should have been extra careful in anything she said.
Well,
and I just don't think that that complies with the elements of the test, either in Boone or the specific findings required under Wells Fargo and Wolfinger.
Well, when the court is relying on the assertions in the response, such as mother has done nothing vindictive in this case, which clearly is not supported by the record. I mean, that statement alone could be sanctionable because mother was clearly vindictive in this case.
I would have to see the line that you're referring to, Your Honor. I really, if that's
so
what we're talking about, I have the court's
also
minute
the
entry.
statement that your statement that the witnesses, the business witnesses, were not listed as character witnesses.
They were not.
Okay, well, I'm looking at the Katz and Bloom letter that was sent to Father's Counsel, and it says, for Mr. Reynard and Mr. I can't say that, Adreon, it says, it is anticipated this witness will testify as to his observations of the parties and his business dealings with respondent, and his observations of respondent's character, behavior, and veracity. Now, isn't that telling somebody that they're listing them as a character witness?
Well, the reason that they were called is to, as far as Ms. Roebuck was concerned, was to talk about Father's credibility with regard to his income. So it wasn't the fact that he was a bad person or a good person. This was a temporary orders hearing, and there was no tax practitioner involved, and these were his partners. So he was trying to say that he earned a certain amount of money, and these witnesses were being called in to talk about the fact that they didn't believe that that was true. Now, they never ended up testifying, but if they had been called to testify, at least Ms. Roebuck believed in good faith that that's what they were going to say. So
No, that's not what Mr. Bloom listed in it.
Well, I mean, as to when you talk about credibility, that was a broad, sweeping characterization of what the any possible ground that they could have testified to, but the specific reason.
The statement was they were not being called as character witnesses. It says his observation of respondent's character.
But that's not all that they were being the nuts and bolts of what they were being called upon to testify about was the income, Your Honor. And even so, you have a judge that is taking into consideration the entire case for the reasons for sanctioning. These were not specific findings. If the judge was going to make a specific finding like that, let him make it. But he didn't make those findings. He made other findings. He didn't say, I am specifically sanctioning on Rule 11 because this statement wasn't true and because that statement wasn't true. He rested on the entire history of the case, exactly what we're told in the cases from the Supreme Court of the United States down to this court that he's not supposed to do.
So you don't dispute there were statements that were not true contained in the reply?
No, I don't think there were statements that were not true in the reply. No, I don't think so. The letter, as my colleague is telling me right now, the request said the main purpose. The main purpose. So there are other purposes, and this court knows. I mean, all of you have been maybe trial judges. I'm not sure all of you have been, but all of you have been trial lawyers, and at least Judge McMurdy was a trial judge, and everybody knows that broad disclosures to the other side before trial, boilerplate responses are that doesn't mean that you can't, that there aren't other main reasons for calling a witness. Again, I get back to, Your Honor, that to answer your question, Your Honor, that these were not specific reasons. This is what you're doing, Your Honor, is you're doing the same thing in your hypotheticals. You're doing a retrospective approach. That's not what we're supposed to do. We're supposed to do a real-time approach.
You lose me when a statement is made in a pleading that says, mother has done nothing vindictive in this case. And yet you have a case full of vindictive actions. I mean, how can you say that you're not supposed to look backwards to see if the statement in fact is true?
Well,
and the record that mother has done nothing vindictive in this case, there
was no finding that at that time, the time that Ms. Roebuck filed her response to that motion for protective address, there was no finding that the real party, that the Ms. KOSTADINOVA had been vindictive. The court hadn't made any such findings. So you know, Ms. Roebuck was entitled to defend her client. This was the main purpose of this response, which we're getting away from, is the fact that she wanted to know where her child was. That's the main purpose of this response. And she was responding to father's motion in which he was saying that mother was vindictively seeking this address. That's what this was really about. All of Ms. Roebuck's statements in that 3-page response were really to answer the court's the motion saying, I'm not producing my address because mother's only being vindictive.
That's not what he said, is it?
I think he did.
In his motion, he did not want to give the address to mother because mother was going to give the address to the business associates.
And where was one fact, Your Honor, respectfully, where was one fact, because I couldn't find any, in the entire record where that statement was supported? And I assert there weren't any facts. And that is not the purpose.
Now about in the Rule 7 motion
Yes.
for protective address.
Yes, and that is not the purpose of a domestic, of a protective address. That's not the purpose, to get a protected address, because you're going to say that, oh, I think mother's 2 witnesses, which were really my business associates, is going to somehow give the information to the partners, and they're going to come, and then they're going to come and they're going to harm me. Where's that in the record? That's nowhere in the record. And and that's what the judge had found. The judge had said in his original denial of their request, I don't believe that father has made adequate showings.
But in your client's response,
Yes. Thank you.
did not dispute that there was an issue about giving the address to the business associates, that could be problematic. The response was mother wouldn't do it, and she's
Right.
done nothing to be vindictive in this case.
Nothing like that to be vindictive. That's the way you have to read that statement.
So we ignore false allegations of abuse that were made twice and were never verified. We ignore the fact that he has no criminal history. We ignore all of those facts, and we just look at this one statement, frozen in time, without regard.
I'm not sure what you mean by we ignore the fact that there is no, I didn't follow that, Your Honor.
When we talk about being vindictive and there's nothing to support, the judge ultimately found that that was a false statement. Would you agree?
I think he found, I'm not sure.
That mother had been vindictive and has a history of being vindictive or engaging in less than veracious conduct. Agree or disagree?
I think that that was part of his finding, but I don't think that that was all of his finding. I think he took his finding in the entire record of the case. And I really, it says right here, petitioner disclosed, this is, I'm going from what father said now. Petitioner disclosed the names of two persons, one of whom is a convicted felon and has threatened father in the past. Well,
The Rule 7 motion.
yes.
Okay.
There's no verification on that. There are no facts. He has the burden to show that. He has the burden. With the history of vindictiveness exhibited by petitioner, father.
I'd like to ask a question.
Yes.
If the Rule 7 protective address was inappropriately entered, isn't that an appeal that Ms. KOSTADINOVA has to appeal? It's not an appeal that's before us in this case, is it?
We are only appealing the rule, the sanctions, Your Honor, just to be clear.
So
We're saying
the issue of whether or not the Rule 7 motion was appropriately granted is not before us,
I think it is.
as that would have required an appeal by Ms. KOSTADINOVA.
I think it has to be looked at as the case within the case under Wells Fargo, because if you're going to sanction a lawyer for responding to the inappropriateness of the Rule 7, you have to look within that case. Just as in Wells Fargo, they looked within the filing of the action, the underlying action that the attorney had filed a bad claim. I think they even talked about the case within the case. And I think that that would be appropriate, Your Honor. She was reasonable in responding to a motion for protected address.
Counsel, I don't want to cut off your argument on that issue, but I am interested in your argument as to why you believe the amount of the sanction was excessive.
I believe that, again, we're talking about a 3-page motion, and we're talking about even if the judge did say that, even if arguendo, you buy the judge's reasoning that these statements were not appropriate in the motion, a $5,000 attorney's fees for those particular statements is just over the top. I mean, he is granting an award against Ms. Roebuck for the original motion, even. Time spent on that original motion, which was denied. And so I think it was just not matching up with the specificity needed in the Rule 11 requirements. And that's my argument. I would rest on that. We've shown that. So I could save the rest of my time for reply.
All right.
If there are no other questions.
Thank you. Ms. Wendler.
Good morning, Judge Winthrop, Judge McMurdy, and Judge Campbell. I'm Terry Rendler, and I've represented Brian Stevens since 2013 in this case. Your Honor, Judge McMurdy, you hit the nail on the head. We are not here today to argue about the Rule 7 entry by Judge Hopkins. Appellant briefed that issue extensively in her briefs. That issue is not properly before the court. Judge Hopkins' minute entry was entered on August 10th, protecting my client's address. They neither filed an appeal nor did they do a motion for new trial on that issue. When they did file their motion for new trial, I objected to inclusion of that argument because it was untimely. Further, it was not raised in their case management statement that was filed with this court. We are asking the court to confirm Judge Hopkins. I don't believe that he abused his discretion, and the award of the sanction was de minimis. I'm not even sure why we're here today on such an award. Rule 31 was violated in this case. Appellant knew, or she should have known from any reasonable inquiry, that the arguments she set forth in her response were not grounded in fact on the history of this case. They were interposed for the purpose of embarrassment and humiliation, to delay the case, and to cause my client to incur unnecessary attorney's fees, which he has. And those fees continue to accrue in this appeal.
What about Ms. Slayton's argument that as the proponent of the motion that your client had the burden to demonstrate by admissible evidence that he was that this was a realistic threat? And I mean, she's basically saying there was no factual basis for the motion.
Are you now you're talking about his request to protect his address?
Yes.
The standard under Rule 7 is very, very lenient. It's a low bar. All he had to assert basically was his concern that there could be emotional or physical harm to him or his family. That's all he had to do. And Judge Hopkins was very clear that Mr. Stevens met that burden. And Judge McMurdy hit the nail on the head again, because Mr. Stevens was concerned that if his address was released to Ms. KOSTADINOVA, she would release it to others. And her vindictive behavior throughout the case was substantial reason enough for him to be concerned about that. So I think if there was a burden for him to carry, I think he did carry it. And obviously Judge Hopkins did too, because that order was entered.
Well, counsel suggests that there needs to be some sort of prior finding or order that the wife is engaged in vindictive behavior before sanctions can be imposed for making a conclusory statement that there has been no vindictive behavior.
Well, I think that there are other reasons that he imposed sanctions other than that one phrase in there. For example, she indicated that the court Judge Hopkins should look at the kind of car that Mr. Stevens drove. Another statement that she made in there was that her client's income was below the poverty level. That was absolutely contradicted by the record in the case. Ms. KOSTADINOVA, in a joint pretrial statement in April of 2014, indicated that her income was $40,000. And Judge Ryan, the judge on the case at that time, entered a child support order based on her indication of her income at $40,000. I believe that's docket number 70. So there were other statements in Ms. Roebuck's response that were absolutely not factual, and in fact they were contradicted by the record. What does that mean? It means she didn't do any kind of a reasonable inquiry into the case. Another point I wish to make about the vindictiveness issue is if Ms. Roebuck had reviewed the motion for summary judgment, and if the courts looked at the record, that motion for summary judgment was this thick. It was totally supported by facts and expert reports. If Ms. Roebuck had read one report, Dr. Corson's report, she would have known, or she should have known, as any reasonably competent attorney would have known, she had a client on her hands that was a problem. A client on her hands that a neutral psychologist had determined had misled the trial court deliberately. Now, if that's not vindictiveness, I'm not sure what the definition of vindictiveness might be. And that was the report from a neutral expert, not from me, not from my client. So to me, what this says is Ms. Roebuck did not do an adequate or reasonable investigation into her client's behavior prior to filing that response, and she made statements in the response that were not supported by the record, and were basically irrelevant to the address issue. What difference did it make what kind of a car my client drove? What difference did it make to the address issue whether her client had income below the poverty level, even assuming that that was true, which it was not? Those are the points I think that Judge Hopkins was looking at. And to your point, Judge McMurdy, I think the court does have to take into account the history of the case. I mean, if you look at the response brief on page 8, I believe I get into this issue. Yeah. One of the factors that is mentioned repeatedly in issues dealing with Rule 11 and Rule 31 is the surrounding circumstances of the case. And in this particular case, I believe that the history of the case was certainly pertinent to what Judge Hopkins had to deal with. He'd been on the case for over a year. He had reviewed the motion for summary judgment and ruled on it, and thus he had a very good working knowledge of this case and the unreasonable nature of Ms. KOSTADINOVA. In addition, there had already been a minute entry issued just days before Ms. Roebuck entered her appearance, finding that certain motions that had been filed by her, Ms. KOSTADINOVA's attorney number 5, Scott Blair, were all denied on the basis that they were unreasonable. So you had minute entries, and you had the history of this case, and you had neutral experts all finding Ms. KOSTADINOVA to be unreasonable throughout the case.
And if I may, counsel, we look at what was before the trial court at the time that the pleading was filed, but evidence that came out after the pleading was filed, how does that inform us of whether or not the pleading was filed in good faith?
I'm not sure exactly what you're referring to.
Didn't Judge Hopkins in his order reference evidence that happened after the pleading was filed that would indicate that he was looking at bad faith on the part of the lawyer, when in fact anything that would happen up until that time would be fair game, but evidence afterwards shouldn't be, should it?
I didn't read his order to be taking into account instances that happened after her pleading. He granted the motion for summary judgment. She came on the case while that motion for summary judgment was pending, and in fact she attempted to file a supplemental response to the motion for summary judgment. Therefore she knew about it. I'm missing something in what the court is referring.
I'm sorry, I forgot to bring out his order, so I can't specifically refer you to it.
He does refer to, on August 8th, I'm looking at the footnote on page 2 of his order, the court specifically found that Mother had taken unreasonable positions regarding whether the settlement existed. That has to do with the motion for summary judgment, indicating that the court would award attorney's fees against Mother. Perhaps that's what the court is referring to. Well, I think that goes back to the motion for summary judgment. So the grounds were there for the court to have found that he was going to impose attorney's fees against Ms. KOSTADINOVA, which prompted her to file bankruptcy. I don't think that he took that particular thing into account when he was reaching this order, though. I think the order is specifically targeted to her response. And one of the issues that Ms. Slayton was bringing up was the findings, saying that the trial court didn't have findings. If the court looks at that order, I believe that there are findings in the order. He found that she filed a pleading without any shred of evidence, that she filed a pleading without making appropriate arguments in response to our request to protect his address. that she filed a pleading that continued to engage in personal attacks on Mr. Stevens. And to me, that's really one of the important points here. She made arguments that had really been rendered moot by the court's approval and acceptance of the motion for summary judgment as a Rule 69 agreement. And again, Ms. Roebuck was the attorney on the record when that occurred. And she knew that the court had approved that motion for summary judgment. That she filed a pleading making an argument that was entirely pretextual concerning the best interests of the child. None of that had anything to do with the protected address. And that she ignored the court's previous ruling with regard to the motion for summary judgment and made arguments that basically just ignored and bypassed that ruling. She filed a pleading that was not meritorious and posited legal positions that were unreasonable. Those are all findings that you can glean from his order. Unlike an order with regards to custody of a child, 25403, where the court has to set forth all of the different factors within that statutory section. Rule 31 doesn't require that. Neither does it require an evidentiary hearing, as they have argued in their brief. The court had sufficient background here so that he didn't need to have an evidentiary hearing. And as the court knows from the case law that was cited in the response brief, an evidentiary hearing is not required, particularly where you have sanctions like this case that are de minimis. There's been case law that has supported the fact you don't even need an evidentiary hearing in the case of a dismissal or the entry of a default if the judge sitting on the case has sufficient information about the case and the instances warrant that kind of a sanction.
Well, in that regard, Ms. Slayton was arguing that the amount of this sanction was excessive, and that it included fees unrelated to responding to the arguable misstatements in the response. Can you address that, please?
Yes, I submitted a China doll affidavit to Judge Hopkins, and I was very careful to limit the application only to those fees that were incurred in addressing the protected address issue, and only those fees that were incurred after Ms. Roebuck came on the case. The address issue wasn't just raised by Ms. Roebuck. It had been raised by attorney number 4, Deborah Brockway. And although there was never a pleading or anything filed on it, that discussion had come up. None of those fees were included in the fee application. And she had an opportunity to object to the fee application. Clearly, Judge Hopkins felt like the fees that were being awarded were appropriate. And again, it's a de minimis amount.
In looking at your fee application, approximately, was it $1,000 of it was regarding the actual filing of the Rule 7 motion, wasn't it?
Gosh, Your Honor, I don't have the fee application in front of me, but if the court says that's what it was, then I will certainly abide by that.
Well, is that appropriate? I mean, you file your motion, and the objectionable response comes in. Shouldn't it be based on just what happens the fee should be based only on what happens after the objectionable response filed?
Well, Your Honor, even if it was, I mean, it couldn't have been very much. You're talking about a $5,600 sanction here. It's really de minimis. And if there were certain parts of the fee application that Judge Hopkins found objectionable, he certainly could have reduced it. I'm sorry, it is what it is. I submitted the fee application and put together all of the fees that were incurred in addressing the address issue, responding to Ms. Roebuck, and nothing else, Your Honor. And Judge Hopkins determined that that was a fair sanction. And again, comparatively speaking, it's fairly de minimis. Did Your Honors have any other questions for me?
Apparently not. Thank you, Counsel.
All right, thank you.
Well, Your Honors, I must say that if this is not reversed, it will be violating, in my opinion, every single case, every single decision from the United States Supreme Court to the Arizona Supreme Court and this court. It is supposed to be a snapshot in time. If a young lawyer or any lawyer is going to be sanctioned by saying, as an advocate for her client in a hotly contested case, my client has not been vindictive in this case because they're countering what the other person is saying, every single lawyer, including me, will be sanctioned.
Well, then I would be careful, Ms. Layton.
I'm not going to be careful, Your Honor, because I am an honorable advocate for Ms. Roebuck, and Ms. Roebuck did nothing wrong.
To say there is no evidence of vindictiveness in this case is actionable.
No, it is not, Your Honor, with all due respect, with the utmost respect. There had been no finding of vindictiveness. If the court, in fact, I take you to the June 21st, 2016 minute entry by Judge Hopkins, where he says at page 7, the court, counsel for father has requested an award of attorney's fees and expenses pursuant to ARS 25324, both in connection with the summary judgment papers and in connection with this matter generally. The court believes further briefing on this point is appropriate. There had been no finding. We're talking about a lawyer's reputation. A trial judge called Ms. Roebuck a shill for her client because she was supposed to know in advance that, and thank you, Your Honor, you did mention it in questioning opposing counsel, at the bottom of page 2, since when is this the standard? I would like to know. Here, and I'm quoting Judge Hopkins, here, counsel knew or should have known that the court would find mother's conduct to be unreasonable. At the same time, mother was in the process for filing bankruptcy, apparently in the hopes that she would not be ordered to pay attorney's fees. Given that, with mother's bankruptcy filing, she may have felt immune from an award of fees. Counsel should have been especially diligent to ensure that only meritorious and reasonable legal positions would be taken. Really, Your Honors, is that the standard we're dealing with in light of the Supreme Court of the United States case law that says it should be a picture in time? No due process has been dealt with here. And I would ask the court to reread the court's orders. It's not the history of the case that we're talking about. It's not some vague after-the-fact notion of whether Ms. Roebuck should have said my client was never vindictive, which she has a right to say that her own client wasn't vindictive. She's being a zealot advocate.
Is there any evidence in this record that would support that statement?
Yes, there is. She was
Tell me to point it to me.
Okay, here it is, Your Honor. This was said in the context of a response to a motion for protective address where they're saying she only wants the protective address because she's being vindictive. And as opposing counsel has stated, this was a hot issue in the case. And David Weinstock had said, Dr. Weinstock had said the addresses should be divulged. The agreement itself, directly contrary to what the judge found, said that parties must give each other their addresses. This was a perfectly reasonable statement by Ms. Roebuck to make. It should be implied from that statement. Everything in that response was talking about the vindictiveness in asking for the address to be disclosed. And we weren't even asking that it be disclosed and made public. Ms. Roebuck said, just tell mother where the child is. And if you can't ask that as a mother, and your lawyer is going to be sanctioned for that, then really, I believe there are some serious problems with Rule 7 and with the award of sanctions by trial judges, because no lawyer is safe ever again if this court does not step in and re-examine this.
Thank you,
Thank you
counsel.
very much.
All right. Appreciate the briefing and arguments in this matter. We'll take this issue under advisement, issue a written decision in due course. We're going to take a brief recess to allow the parties from the next case to come forward and get set up.